The jury came back. The case is over. And OpenAI's founding mission is exactly as settled as it was the day Musk filed. Which is to say, not at all.
You're listening to Musk v. Altman Daily, and the trial's done, the IPO runway's wide open, and the actual question everybody came for is still just hanging there.
We're watching three things this morning. Who even has standing to take this up now that Musk's clock ran out? What the conversation says is the core unanswered question about the charitable mission, and what it means that Musk and Altman both walked out of Oakland and straight toward Wall Street.
A trial that was supposed to put a leash on a runaway AI company just cleared the way for a public offering. That's where we are.
Here's Ian Murray at the conversation.
Crucially, the jury did not rule on the core claims of the case. These included whether OpenAI, the company behind the popular artificial intelligence AI chatbot ChatGPT, strayed from its founding mission, and whether Altman and OpenAI's co-founder Greg Brockman enriched themselves at the expense of a charitable purpose. It decided only that Musk had waited too long to sue in relation to his core claims about breaches of a founding contract or breach of charitable trust.
The conversation puts it plainly. Oakland decided one thing. Musk waited too long and left the real fight, nonprofit mission versus shareholder return, untouched. No ruling on whether Altman and Brockman enriched themselves. No ruling on breach of the founding contract.
And here's the kicker. The conversation says a Musk win could have neutered OpenAI. Instead, they walk out of Oakland with a clean path to IPO. The thing that was supposed to be the guardrail turned into the green light.
So the question now is, who actually has standing to pick this up? State attorneys general, charitable regulators? Those are the people with a live lane. Because Musk's window is closed on laches grounds, and a private plaintiff would run into the same calendar problem.
I kept wondering all week whether a court was even built to answer what OpenAI promised in 2015. Turns out this one wasn't. But that doesn't mean the question went away. It just got handed to someone who hasn't stepped in yet.
This one's from the Economic Times.
A jury ruled Elon Musk waited too long to sue OpenAI, rejecting his claims that CEOs Sam Altman and Greg Brockman broke their nonprofit agreements. Musk sought $150 billion in damages and the removal of the executives, but the jury sided with OpenAI, ending the 3-week trial.
Economic Times has the recap, and the number that never got adjudicated is worth saying out loud. $150 billion in damages, plus the removal of Altman and Brockman. The jury never reached any of it, so they never weighed whether it was credible.
2 huge asks. The biggest damages number I've ever heard in a tech case, plus 2 CEOs fired, and the whole thing dies on a filing deadline. Mission question, leadership question, 0 answers on either.
Which is why the conversation's framing matters today. The founding mission question walks out of Oakland untouched, and now the people with actual standing are state attorneys general and charitable regulators, not a private plaintiff racing the statute of limitations.
And the kicker from CNBC. The second Oakland ended, OpenAI's IPO prep kicked into gear. The case that was supposed to put a public check on a runaway for-profit AI lab just cleared the runway for it to go public. That's the story now. So the jury tossed Musk's case because he waited too long. But does that mean OpenAI gets a free pass on whether it's still honoring its original charitable mission?
The short answer is, the clock ran out on Musk specifically, not on the underlying question. The 9-person jury found, after less than 2 hours of deliberation, that Musk missed the 3-year statute of limitations window. Per the AP, OpenAI argued anything before August 2021 was off the table. Judge Yvonne Gonzalez-Rogers accepted that verdict and dismissed all of Musk's claims, including allegations that Altman and Brockman unjustly enriched themselves and violated a founding promise to keep OpenAI a nonprofit dedicated to humanity's benefit. But Musk donated $38 million to OpenAI and co-founded it in 2015, per MIT Technology Review. And the core tension he raised, whether a charitable nonprofit can restructure into something Wall Street would recognize, didn't get resolved on the merits. The court never ruled on whether the mission was actually broken. That question still belongs, in the normal course of things, to state attorneys general, who have independent authority over nonprofit assets and charitable trusts, and California's AG had already been looking at OpenAI's restructuring separately from this trial.
Musk says he's going to appeal. So could he actually get another shot at the merits, or is this just a vow to make noise?
He's vowed to appeal, calling the outcome a calendar technicality in a post on X. But appeals on statute of limitations rulings face a high bar. You'd need to show the trial court got the law wrong, not just that the underlying claims were strong. Meanwhile, OpenAI is still heading toward a highly anticipated IPO, and the for-profit restructuring question is very much alive for regulators and state oversight bodies to weigh in on. Watch California's Attorney General as the more likely next arena. From Ashley Kaput, Laura Kolodny at CNBC.
Elon Musk lost his lawsuit against OpenAI CEO Sam Altman on Monday, ending one round in the fight between the former friends and co-founders and setting the stage for an even bigger battle as the billionaires gear up to lead potentially record-setting IPOs. Musk's SpaceX, which was valued at $1.25 trillion in February after merging with artificial intelligence startup xAI, is planning to disclose its prospectus as soon as this week.
The gavel came down Monday, and by this week, SpaceX is dropping an IPO prospectus. CNBC's framing is right. Oakland was round 1, Wall Street is round 2, and the disclosure rules are completely different.
So the case that was supposed to hold OpenAI accountable for walking away from its charitable mission just cleared the runway for an $850 billion IPO. The court looked, shrugged on a calendar technicality, and handed Altman the biggest possible exit ramp.
Worth noting, the jury never weighed in on whether OpenAI's mission conversion was legitimate. The $150 billion damages ask, the removal of Altman and Brockman, none of it was adjudicated. The court fight we left unresolved is already turning into a market story. Next stop, IPO scrutiny for both Musk and Altman.
And Gene Munster at Deepwater is out there saying, now we get to see what these companies can really build, which is one way to read it. The other way is the public markets are about to do the accountability work a San Francisco courtroom just punted on, except shareholders care about returns, not charitable mission.
Omaha Daily Record with Barbara Ortute, Matt O'Brien.
The trial's outcome could sway the balance of power in AI, breakthrough technology that increasingly has raised fears about its potential impacts on the economy, society, and even humanity's survival. Scrutiny of Altman's leadership comes at a crucial time for the company and its competitors, Musk's own AI firm and Anthropic, formed by a group of 7 ex-OpenAI leaders.
This one's from the AP via the Omaha Daily Record. Closing arguments piece, Dateline Oakland. Worth flagging because it's pre-verdict coverage, but the IPO framing buried in it is now the live thread. All 3 firms, OpenAI, Musk's xAI, Anthropic, were heading toward what the AP called among the largest IPOs ever, and the trial was the one thing that could have derailed at least one of them.
So the case that was supposed to be a check on a runaway for-profit AI company just cleared the runway. Latches kicked in, the jury went home in fast, and now OpenAI's IPO prep kicks into gear with zero merits ruling attached to it.
The $150 billion damages ask, Altman's removal, the structural changes to OpenAI, none of it got adjudicated. The jury never had to decide whether any of those demands were credible. That number just evaporated on a calendar technicality.
2 enormous asks, $150 billion and 2 CEOs fired. And the answer the public gets is, you filed too late. Mission question, leadership question, both walk out of Oakland untouched. So who picks it up? Because the public markets sure aren't built to answer whether OpenAI broke a charitable trust.
The conversation's framing today is useful here. The people who actually have standing to chase that charitable mission question aren't private plaintiffs like Musk. It's state attorneys general and charitable regulators. That's the door the judge left open. And it's a different arena with different rules than what just closed in Oakland. If the Musk-Altman fight has you thinking about what powers AI, try the Data Center Daily, a daily briefing on AI, compute, hyperscaler, CapEx, the grid, chips, and energy markets. Find it wherever you listen to podcasts. You'll find links to every story we covered today in the show notes. So, if one caught your ear, you can dig in further there. That's Musk v. Altman Daily for this Wednesday. This is a Lantern podcast.